senior management at the Office of Procurement Regulation, as well as members of the Procurement Board of Trinidad and Tobago. They will be sharing with us their perspectives on the office's powers to audit and investigate, potential disruptions to businesses that are subject to an audit and investigation, the cost of these audit and investigations, and even how technology has transformed these industries. We also want to hear from you, our members of the public, and answer as many questions as possible. So, we will be conducting today's proceedings in 2 segments. We will have the roundtable discussions where you hear from members of the panel. We will proceed to a 10-minute break where we collate your questions, and then we will come back for a 30-minute question and answer segment. So feel free to drop your questions in the chat. If you would like to direct your question to a particular panel member or have your question answered by a particular panel member, please include the name of that panel member in your question. Now, only those questions that are relevant to the topic of discussion today will be answered, and that is because we want to keep the question and answer segment relevant and time-bound. So without further delay, I'm truly honored to introduce the distinguished members of today's roundtable. We will first begin with our external expert guest panelist, Mr. Stefan Gray. Mr. Gray is Executive Head of the Caribbean Institute of Forensic Accounting, the Managing Director and International Liaison of CIFA Consulting, an expert panelist at Streamhouse Switzerland, and the Head of Forensic and Investigative Services at Baker & Partners in the UK. He is an international asset tracing expert, certified fraud examiner and forensic auditor with 18 years experience and expertise in asset tracing, contractor audits for oil and gas, corruption investigations, forensic accounting and auditing, follow the money investigations, and corporate intelligence. So welcome to you, Mr. Stefan Gray. We have with us also today Mr. Nigel Irish. Mr. Irish is a qualified accountant and fellow of the Association of Chartered Certified Accountants. Nigel also holds an executive MBA from the Arthur Luckjack Graduate School of Business. He is currently the Vice President, Director of Finance for the Massey Gas Products and Energy Portfolio. He has over 27 years experience in all aspects of finance and accounting and overall business management. Nigel is also chairman of the Investigation Tribunal for the Institute of Chartered Accountants of Trinidad and Tobago and a director and a treasurer on the board of Neil Massey Credit Union. So welcome to you, Mr. Nigel Irish. From the Procurement Board of Trinidad and Tobago, we have our deputy chairman, Mr. Robbie Bowler, who is a chartered accountant with over 19 years experience, having held senior audit roles at PricewaterhouseCoopers in Barbados, Deloitte & Touche, throughout the Caribbean, and is a principal of Robbie Bowler and Associates. Robbie was admitted to the membership of the Association of Chartered Accountants in 2005 and became a fellow member of the Association of Chartered Certified Accountants in 2010. He is also the recipient Chartered Accountant designation from the Institute of Chartered Accountants of Trinidad and Tobago. Additionally, Robbie holds a practicing certificate from ICAT and was certified as a Certified Internal Auditor in 2017. Robbie was also admitted to the Association of Anti-Money Laundering Specialists in 2018. So welcome to Deputy Chairman Robbie Bowler. Also from the Procurement Board of Trinidad and Tobago is Ms. Natasha Ashby, who is an attorney at law with 25 years experience. Natasha is currently the Vice President of Law and Corporate Affairs and Corporate Secretary of Atlantic LNG Company of Trinidad and Tobago, where she is responsible for the company's corporate governance, legal, ethical, and compliance functions. Natasha is a UWI alumna who holds a Bachelor of Laws degree and a Master of Laws degree in Corporate and Commercial Finance. Natasha is also a member of the Disciplinary Tribunal of the Institute of Chartered Accountants of Trinidad and Tobago. So welcome, Board Member Natasha Ashby. And last, but certainly not least, we have the OPR's Head Audit and Investigation, Ms. Shada Nanan, who has over 15 years experience in internal audit, risk evaluation, and global banking in organizations such as RBTT Financial, Caribbean Finance Group, and Environmental Management Authority. Shada also holds a BSc in Management, ACC accreditation, a diploma in Forensic Accounting and Fraud Detection, and an MBA from the Edinburgh Business School. Shada is also a certified internal auditor, a forensic certified public accountant, and a certified fraud examiner, holding memberships at the Institute of Chartered Accountants of Trinidad and Tobago, the Institute of Internal Auditors, the Association of Certified Fraud Examiner, and the Forensic Certified Public Accountant Society. So welcome, Mrs. Nanan. So Shada, to start off with you as the OPR's internal expert on the panel, how would the OPR determine which public body it intends to investigate?
So good afternoon, everyone. Good afternoon to our listening audience and to our panel members. Marita, that's a very interesting question, especially on the heels of proclamation, where we have so much discussion in the public domain taking place about the Act. So to answer your question, there are two main triggers through which an investigation can take place. In the first instance, an investigation can be triggered as a result of a complaint that comes to the office by anyone who is interested or is engaged in public procurement. And there are also different measures by which a complaint can come to the office. In the first instance, the OPR has established a whistleblowing forum. It is fully operational, but we will only launch that upon proclamation. So a person can go on to the website and they can make a complaint there. They can do it either fully anonymously or they can state their name and give us that information. So they can do that in that regard. In the second instance, the office has on its website a complaint form. So someone can also go download the complaint form, put in their information, and submit it to the office. It will go through the relevant channels and come to the Audit and Investigation Department. The third means by which a complaint can be made is via walking. Someone can come to the office and physically make a complaint. That complaint, again, will be channeled to the relevant department and then come to the Audit and Investigation Department. So that's one way by which an investigation can be triggered. The second way by which an investigation can be triggered is through the regulator's office. So there are two means by which the regulator can trigger an investigation. The first is one as a result of public interest, where there is a general public interest in a matter. So there is something that we see in the public and there's an interest by the public in it and there's an outcry for the office to take an interest in it. And then there's something in the instance where there's something that is just in the public domain. So there may not be this public outcry for it, but the regulator, based on the functions of the office, and the function in terms of public procurement, where we're using public funds to procure goods and services, it falls under the armpit of the office, and the regulator can initiate an investigation as a result of that. So those are the two means or two triggers by which an investigation can occur.
Okay, so we've heard about the two ways by which an investigation can be initiated. Give us an idea of how would the OPR decide whether to proceed with any particular request for an investigation?
So this is new. This is new legislation. This is new to Trinidad and Tobago. So the office does not, we don't have an idea in terms of how many investigations are going to come to the office. So in the first instance, we'll have to prioritize those investigations. And there are several factors that we will use to prioritize those investigations. For instance, for persons, as I would have explained earlier, if a person is making a complaint, is the complaint coming with evidence? Is it that the person who is either going on the whistleblowing platform, person who's coming to the office, person who's downloading that form, are they going to be submitting evidence to support their claim? Because the office is not one where we will say, in Trinidad, as they say, I have a gut feeling, or I hear this on the side of the road. It's not something that the office will engage in. So there must be evidence to support your claim. So that's one instance. In the second instance, in terms of the resources that the office has. So the office has limited resources. So we will also need to prioritize those cases based on the evidence that we have, the resources that we have. The office also has the ability to recruit experts in the field that we need. So based on that recruitment process as well and the experts that we need, that will also play a factor in terms of how we go about investigating. Another factor will also, that will be important, would be those offenses that has statutory limitations. So those will probably take a priority in terms of when that limitation will expire and how the office will treat with it. Another factor that the office will consider is in terms of If it is that an external party, let's say the TTPS, the ACIB, the FIB, if they are also engaged in an investigation that comes to the office. So upon completing the complaint form, there is a question on that form which asks, has this complaint been made by any other party? And if in that instance we see yes, we will make an assessment to determine whether or not we will be proceeding with that complaint, because we do not want to run a parallel investigation that is currently being undertaken by the TTPS, the ACIB, and then we tarnish some sort of evidence that they may be looking at. So that's another factor. And I want to say the last factor that we will look at is in terms of those persons who continuously come to the office to make complaints about various matters. But not only that, those that there may have been an outcome as a result of an investigation, let's say again by the TTPS, the ACIB, the FIB, but the complainant is not happy with that outcome. So they now use another channel. So they come to the OPR hoping that the outcome would be different for them. So we will look to see if has that investigation taken place already, or is that investigation closed, what the outcome was. In addition to that, if we see that a person is continuously coming to the office to make claims, that will also be a trigger for us in terms of how we prioritize those investigations.
Okay. So we've heard about the initiation aspect as well as how the OPR will prioritize those investigations it chooses to proceed with. So Mr. Irish, based on your experience as chairman of the Investigative Tribunal of ICAT, do you have any thoughts on the process that Shada has discussed?
Yeah, certainly. Good afternoon all. Good afternoon to the fellow panel members, and good afternoon to the viewing public. Certainly, in terms of investigation, a priority has to be given in terms of what you investigate and what you don't investigate. You get a lot of complaints sometimes that are not valid, and you are asked to investigate it. So as a committee, we will sit, evaluate whether this is a complaint that should be investigated based on evidence. We will ask the complainee if there was additional evidence they can provide for us to move forward with the case. If not, we will make an assessment as to whether this is a valid investigation that we should pursue or we should not. So it is based on, as she said, evidence that would have been provided by the complainant.
Okay, great. So we also know that investigations can be broad and invasive to business operations. So I have another question for you, Mr. Irish. What can an organization under investigation do to work with the OPR's investigators to ensure access to the information that the OPR requires to thoroughly investigate the case, but simultaneously reducing the business disruption and the costs associated with collecting, reviewing, and producing the information?
Okay. I can answer that in two parts. It depends on the type of investigation. Is it an audit for an issue that arises from maybe a fraudulent activity, or is it a compliance audit? In the case of an investigation that is really investigating an issue, what may happen is that you would want to ensure that you are protecting the rights of the organization, cooperate with the institute, but also ensure that you seek legal counsel in the way you interact with the OPR. In the case of a compliance audit, what you may want to do is, because you're probably trying to get approval to actually conduct business with a public institute, so you will be more cooperative in that case. And within recent times, we have seen the use of technology. So audits are conducted with minimal interruption, because you can transfer files via electronic means, and therefore it reduces the impact or the disruption that can take place by having auditors in and out of your premises and having to accommodate them and stuff like that. So because of technology, audits have become a lot more, I would say, a lot easier to conduct, because you can transfer files electronically. And I saw in the Act that there's electronic transfer files. Yeah. So that is an important part of the legislation that will allow for electronic files transfer. So I think that in itself will reduce the cost of audits, because there's less paper, it's less, people having to transport from different areas of the country to get to a particular location. So in that case, utilization of technology will improve the audit and also speed up the time frame that it takes for the audit to be conducted.
Okay, great. So we've discussed the investigative powers of the OPR. But under the legislation, the legislation also speaks to the auditing powers. So, and this question is for Deputy Chairman Robbie. What processes would the OPR use to conduct an audit of a public body's procurement function?
Thank you, Marissa. Good afternoon to my fellow panelists, and good afternoon to the listening audience. The audit function of the OPR is grounded in sections 13.8, 13J, and 14.1b of the Act. These sections give us the power to audit, review, and also to perform inspections at public bodies in accordance with the Act. Now, the purpose of the audits really is to ensure compliance with the Act and the guidelines and the handbooks, and also to reveal deviations from accepted standards, identify violations, and to keep responsible persons accountable. Now, of course, we would recommend steps to ensure or prevent breaches happening in the future to these organizations. Now, the audits are broken down into two categories and outlined by my fellow panelists. We have compliance audits, and we have a bucket called performance audits. The compliance audits is really where we audit against the Act, the handbooks, and the guidelines, and so forth. Performance audits really looks at efficiency, effectiveness, and the economy and value for money. Now, the standards that we use to conduct these audits are the INTUSI standards, and also we'd also use the principles of ISAs to conduct our audits. Now, in terms of really the process to select, we would do a risk-based audit planning every year. An audit universe is established. We would look at the national budget, list of public bodies, any national strategy documents, changes to legislation that were made or that is coming into force. And then once we do that, we would look at the public bodies and we would consider several risk factors which are then weighted against certain criteria. For instance, we'd look at the value of the spend, the activity. Planned versus actual. How big are the deviations? How important is that activity to the public or national development? How complex is the activity? Is it routine? Is it one-off? We'd also consider the experience of the staff at the public body. Were there changes to staff, procurement officers, accounting officers, disposal staff, and so forth? We'd also look at the process and system changes within the public body. We'd also consider if the handbooks were approved or unapproved. We would consider if complaints or reports were made about the public body, and if the public body has a history of breaches or non-compliance. And of course, we would factor in any discussions we have with key stakeholders, the Ministry of Finance, permanent secretaries, board of directors, audit and disposal committees, FIU, the Auditor General, to consider if there are any additional auditable areas we should include or consider to include within our audit plan. Now, our process is iterative. We are constantly looking for areas which might need to be considered and included on our audit plan. Now, I must make the point that focus is placed to ensure that the public bodies and the activities which are audited, that we have enough coverage for procurement, disposal, and retention activities.
Okay, great. So, Shada, do you have any additional comments on the audit processes of the OPR?
So, yeah, Marissa, based on what Mr. Bowler would say, he's covered in terms of the handbooks, the guidelines, the Act, the regulation. A couple other things that would form part of the risk assessment that the audit and investigation will be doing in terms of how we go about identifying a public body by way of Section 14 of the Act, and again under the functions of the Act of the Act. So when we look at, we have the public bodies that will be in categories in terms of small, medium, large by way of their spend, their dollar spend. When the budget is allocated by the Minister of Finance, that allocation we will look at, because each public body is required to identify their procurement activity and to prepare 6 weeks after the passage of the budget and annual procurement plan that will be submitted to the office. Upon the submission of that plan to the office, one of the triggers or one of the red flags for the Audit and Investigation Department in terms of not only procurement but also in terms of the disposal would be the variations from the plan. In that, is it that when the plan is established, when you get your funding at the start of the year, during the course of the year, you arbitrarily decide that you're going to change the procurement activity that you had established on that plan. So that will be one of the main triggers for the investigation department. We've heard in the past, or the public has generally heard, in terms of when you have contractors continuously saying that they're not being paid for the jobs that they have completed in terms of procurement activity. So another trigger for the investigation and the audit department will be in terms of where is that funds, in terms of when you look at the dollar spend and you look at the activity that should have been completed. When we say, okay, why was this activity not completed, or where was the funds reallocated to, in terms of if we have $600 million that was assigned to Project A, and we now see that Project A is at $700 million. Where was the other $100 million? Is it that you wrote to the minister and you requested additional funding? Or is it that you took from Project B and now you're going to place it into Project A? So those would be some of the indicators for the office. In addition to that, the public body is now required to send to the office that change in terms of the annual procurement plan. So that would be one where we see that public bodies continuously changing their procurement activity or the procurement plan to send to the office. Mr. Bowler would have also spoken to in terms of the personnel for the public body. But specifically speaking, in terms of the name procurement officer and the accounting officer, the appointment of these two persons who are key in terms of the procurement function and their accountability to the office in terms of the procurement spend for that particular entity. So those are some of the factors that the audit and investigation will be looking at in terms of, have you appointed a named procurement officer? Is this person suitably qualified to perform that function? So is it that you're just naming a person within the entity who does not have the skill set, who does not have the academia to follow, in terms of if it is a directive is given to that person, they would not be able to say, well, they can question, why am I doing this? Or is it that I'm just following the authority that has given me that instruction? So those are some of the factors that the A&I department will be considering in terms of developing an audit plan for the year to proceed with an audit.
Okay.
Chair, I have a question for my fellow panel member. And that question really surrounds what happens in the event that, I mean, we are currently in a very inflationary period. So a budget may have been allocated for a project, say 600 million. Yeah. And because of inflation, that project balloons to 700 million or 800 million. As we have seen, certain projects, steel prices have, will that be considered before an investigation is undertaken, and not just based on a movement in pricing?
Certainly not, certainly not. In that, it's not that the office is this body which says you have to follow this part. This is the part at the start of the year when you develop your annual procurement plan and you say you have to go from point A to point B to point C. And when the audit and investigation department goes into the public body, we now look that you must only follow point A, point B, point C. The public body must document in terms of their record why it is that there was that deviation in terms of the spend. So it's not that the office is an unreasonable, or the audit and investigation department will be an unreasonable one in terms of when it is we see the proper documentation, the proper rationalization for a project where we have the prices we have the prices of steel doubling, where we see a construction is taking place, and we understand that within that the projections for those increases may not have been documented in the plan. So we would see those changes, but it must be properly documented, it must be properly approved as well, and it must probably come to the office as well in terms of why those things are happening.
Thank you.
An excellent question, Mr. Irish. So, Mr. Gray, I want to throw you into the mix as well, because we heard Mr. Irish speak to instances where there may be changes. So what are some areas that you think that an auditee can do to protect itself then, especially in today's climate?
With regards to changes in price?
With regards to changes in price, it could be their internal procedures, it could be their manpower.
Well, Good afternoon. Afternoon to the panel. Well, from a forensic point of view, changes in price, as Charlotte said, could be reconciled easily. But I think it's a mistake where auditors just look for a change in price. Because what if I overstate my budget? What if the malfeasance is actually in the budget prices? So what happens over the years, people have gotten accustomed to auditors looking at their budget and their actual to get a variance and picking the line items to audit based on the variance. So what if I bump up my budget with the improprieties, then the actual will equate to the budget, good, and the auditors have no variance. So it goes two sides. You can have, you look at the variance, but most importantly, the most important audit steps in the modern world where people are getting smarter is to actually look at your budget.
Okay, so as it pertains to the audit process as well, because we did hear Ms. Iris speak to technology, in terms of external audits, is it a costly thing to an organization when they are subject to an external audit?
Well, it costs in terms of time. I don't know if you all have a charge for the for your time. Yeah. All right, but technology plays two things. It reduces the time and effort of both the host organization.
Right.
In other words, or the team does not have to go into the company and take up room in the boardroom for 20 days and drink all the coffee and the tea and so on. Right? So that's one aspect of it. Secondly, it's a protection. So for example, if you have an investigative type of audit, we have seen where in a lot of state enterprises, not only in Trinidad, where things come burning down, right? Because they know the auditors are coming. Good. So if you can, as Mr. Iris stated, log in from outside, transfer files as your act has stated, then you can reduce that sort of red flag that an audit is on investigation is taking place. Also, a good proper investigative step, as you'll see in a lot of literature, is to try for people to know that an investigation is taking place last. People should not know. And the technology will also aid in that, right? Because you can stay from your outside or virtual and do the audit and people not know.
Okay.
Yeah?
Great.
Mr. Gray, just to clarify one thing, by way of the audit and investigation function, they're two separate functions of the office. And so while it is normal or it is the industry best practice for an investigation, as you would have indicated, for it to be known at the last stages, that may not always be the case for the OPR, in that if it is that an investigation is initiated and the office is unable to access records, personnel, file, documentation, the office has to go to the courts to get an ex parte order, and we can in that instance, we would compel the public body. So it is almost at the front of the investigation in that instance, where it is the office now has to inform the public body, we are coming in. You now have, if it is in the instance where it is that they were not willing to participate in that investigation or not willing to provide records, personnel documents, whatever we were asking for at the onset of the investigation, the ex parte order now compels that public body that, hey, you now need to provide the OPR with the documents that they are requiring. So it's a little bit different in that regard.
Yeah, but two things. If you are doing an investigative audit to the body, then I assume it's taking place at head level, board level, and not actually played out in the public. So that is one advantage. And two, I should think that the public bodies will be quite compliant, so I hope you don't have to go through that ex parte first up. And if you do have to go through that ex parte, you might as well call an investigation once. Yeah. So.
Okay, great. So we spoke to the audit process. We spoke to the investigation process, some things that public bodies can look at as it pertains to, getting ready, protecting themselves. We have technology that we've all spoken to that reduces the cost of these audits, these external audits and investigations. So what happens next? So the OPR has conducted an investigation, or it's initiated an audit action against a public body. And I will pose this question to Board Member Ashby. So what are some of the legal implications of an audit or investigations for public bodies so they are aware?
Okay, good afternoon, Marisha, and good afternoon, fellow panelists, and to the listening and viewing audience. I guess where I'd like to start with that is actually with the mandate of the OPR as contained in the Act. And as we are aware, it is in respect to public procurement, retention, and disposal using public funds that the principles of good governance are adhered to. Good governance, accountability, transparency, and value for money. And in that regard, the first initiative of the OPR is really towards ensuring compliance. Right. You know, much of what the OPR has been engaged in for the past few years since the startup of the organization and proclamation enabling of certain parts of the legislation enabling that is to bring public bodies along to educate, the provision of the handbooks, the guidelines, ensuring that good governance and proper procurement process is in fact followed. That is also going to be the case where the OPR is called upon to audit or to investigate. And in accordance with the Act, the OPR can give directions or instructions with a view to ensuring that its mandate and the provisions of the Act are complied with. So, you know, it's all of our hope and intention that after all of this work has gone in at the forefront of it, that there will be compliance, and that everyone will see the benefit of compliance to the individuals concerned, to the organizations concerned, and to the wider community. So that's the first approach. Of course, we also are aware that there will not always be compliance, and that's another very important aspect of the Act. And there is significant sanction penalties that are prescribed, various sections delineated in Schedule 1, put out in sections 60, 59, etc., which treats with how infractions, breaches are to be dealt with. That being said, the OPR does not have an enforcement arm, and there is no right to enforcement. So again, in accordance with Section 45, the OPR being a creature of statute, where an investigation suggests the OPR is reasonably satisfied that there has been a breach of the Act, that report is then handed over to the Director of Public Prosecutions for the DPP to take such action as he sees fit. And so I think, but what I want to leave with everyone is the aspect of compliance for the public good. And that's where we should be focused.
Yes. Well, I'm happy you made the point of the OPR really basing success on compliance based on the building of the capacity of these public bodies about the legislation, the regulations, the handbooks, and guidelines. But then we can go on to Section 70 as well, and there has been some public discussion as it pertains to Section 70. And for the audience benefit, I'll read the entire section. So Section 70 states, nothing in this Act affects the validity of any proceedings commenced or any contract entered into before the commencement of this Act. But if this Act would have been applicable to the proceedings or the contract if the proceedings had commenced or the contract had been entered into after the commencement of the Act, the conduct of the proceedings and the performance of the contract shall, from the commencement of this Act, be subject to such directions as the office may issue under Section 14, subsection 1c, for the purpose of achieving the objects of this Act. And for completeness, Section 14, subsection 1c states, in the performance of its functions, the office may issue directions to public bodies to ensure compliance with this Act. So, does Section 70 give the OPR powers to investigate procurement activities that would have commenced prior to full proclamation of the Act?
Okay, so I guess where I would start is actually in Section 6 of the Act. Mm-hmm. So, Section 6 of the Act provides that where public procurement, retention, or disposal is not conducted in accordance with the Act, or if there's a contract that's not in accordance with the provisions of the Act for public procurement, retention, or disposal, it shall be void and illegal. So, but we then have to determine when does that take effect from, because the Act, as we acknowledge, establishes certain new offenses or prescribes penalties that, albeit that these would have been offenses under existing legislation, there's a new penalty schedule. And so what Section 70 does is make it clear that in respect of rendering a contract, by way of example, void or illegal under Section 6, that cannot take place with respect to a contract entered into or proceeding prior to the proclamation of the Act and prior to the operative Section 70 and indeed Section 14(1)(c) that you also referenced coming into effect. So, with respect to contracts entered into prior to the operative Section 70 and 41(c) coming into effect, those cannot, by virtue of Section 6, be deemed to be illegal and void. Then Section 70 goes a little bit further with respect to proceedings taking place under such contracts. And from the proclamation of the Act, what I'll refer to as the operational sections of the Act, from that time, albeit that the contract or proceeding might have been entered into prior to the proclamation, from the time of proclamation, the office is entitled under Section 14(1)(c) to give certain directions. And those directions could be for the provision of information or directions as to how the contract or proceeding should continue to be implemented so as to ensure that the provisions of the Act are adhered to. So it's not, as wide as the deep blue sea. We continue to operate within the confines of the Act and within the confines of the mandate as prescribed by the Act.
Okay, great. So just for clarification, so those contracts that would have been entered into prior to proclamation would follow the handbooks and guidelines that would have already been established by that particular public body?
Well, I'll get two potential answers to that. There's existing legislation.
Yes.
There's existing legislation under which, and there are offenses that you will find delineated in the Act that perchance, if the evidence supports it, an existing criminal offense. So with respect to offenses, if there's existing legislation or any other law that applies, these continue to apply until there's proclamation. A new offense created by the Act will not be applicable because, general principle with respect to retrospective application, an individual or public body must be aware as to what they are being called to comply with. That being said, as we engage with public bodies, as the officers of the OPR engage with public bodies, in anticipation of the proclamation of the Act, it is the intention that persons get their houses in order. To, again, go back to the basic premise, ensuring compliance, and Shada alluded to this. That's for the benefit, that's for the overall greater good of this society. So it's not geared or aimed towards, well, let me see, how far I can push this until the Act is proclaimed. It is to ensure adherence and compliance, and that must start today.
Okay, great. So, Mr. Gray, do you have any thoughts on the powers of the office under Section 70 to investigate pre-proclamation and post-proclamation?
Well, I've seen other types of legislation, for example, asset recovery legislation, for example, in Guyana, where they went retrospective. I think it's important that if it does not have retrospective, that it contains it, right? Because public procurement, these payments and these contracts could go over time, right? Present and past. You have construction projects going on over 10 years. For example, Barnard Stadium, that went over 12 years or something like that. Good? So I'm sure there are other projects like that. So I'm a fan of retrospective. Retrospective.
Great.
Attractive, sorry.
Great. So thank you very much. So we've had a lot of discussions today about the powers of the office to audit and investigate. We discussed the processes. We discussed new technology that may assist public bodies. We also discussed, for instance, the legal implications and the retroactivity of Section 70. So back to the main topic of today's roundtable discussion, and I will start with you, Deputy Chair Bowler, and I will go around the panel. So do you think, based on the discussions today, that the Office of Procurement Regulation has unfettered powers to investigate and initiate an audit action pursuant to the legislation?
Thank you, Marissa. And my view on that question is no. And if you look at certain sections of the Act, and it was raised earlier by my fellow panelists, for instance, looking at getting an application and getting authorization from a High Court judge to enter premises of a public body, that must be sought. Another point was raised where it is we believe if there is a reasonable grounds for an offense, a file or a report must be made to the DPP, and then he or she would take action. So my answer is no.
Okay, great, thank you. Mr. Gray?
I agree with Robbie. My answer is no as well.
Yeah.
Two things. In perusing the Act, I only saw two words come up, bid rigging and collusion. So if you're talking about investigations, you need much more words than that. So to cover the entire scope of procurement, possible what they call procurement fraud schemes, or misappropriation, or corruption, right? So unless I'm mistaken, I've not even seen the word corruption in the Act. So the answer, no, that doesn't fully cover investigative powers.
Okay, great. Thank you very much. Mrs. Nanan?
So Marissa, to answer the question, you said to be brief, so I'll try to be, but just to clarify, when we speak unfettered powers by the office, is it that the office has uncontrolled, unlimited powers? And the answer to that is no. But the office does have powers.
Yeah.
And the powers are stated within the legislation. So the Act does give the office under Section 13 the ability, under Section 14, sorry, the ability to audit. And under Section 41, 42, 43, it also gives the office the ability to investigate. And under Section 42, subsection 6 of the Act, we can comply, a public body, or a public body has to comply with the directive of the office. So while we may not have unfettered or uncontrolled powers, the office does have some remit in terms of public procurement and disposal. So the answer to the question is no, we don't have unfettered powers, but I want to say that the office still does have some sort of powers
to audit and investigate. Okay, great, thank you. Ms. Irish?
In looking at the Act itself, the Act does provide some limitations to certain bodies under the Act. So, some hospitals, some, depending on the type of goods you're procuring. So the Act in itself kind of limits the power. So the answer, no.
Okay, great. Yes, board member.
Okay, so the OPR is a creature of statute. It must operate within the confines of the statute. But that being said, I do agree with Charlotte. There is power to investigate, to audit, to report, and the fines and penalties as delineated, once the evidence is sufficient and satisfactory, will be applied. So in its widest sphere, unfettered, no, it's a creature of statute. The enabling legislation will dictate how the regulations are detailed. But within that, there is considerable power, and rightfully so, in order to ensure that the mandate is fulfilled. So.
Okay, great. Thank you very much. So a great thank you to the panelists today. We will proceed to our break so we could collate the questions that you have been including in the chat, and we will be coming back for a 30-minute question and answer segment. So we'll proceed to a 5-minute break. Thank you.
Saving our world. It's a topic that we've heard much talk about in recent years as climate change continues to cause many countries to take stock of their contribution to this global crisis. Here in Trinidad and Tobago, the Office of Procurement Regulation is committed to doing all that we can to ensure that our public bodies keep their demands on global natural resources to a minimum. But in an age so heavily driven by consumerism, the drive to reducing our eco-footprint needs to be championed at all levels, including procurement. Procurement is a business's process of acquiring goods and services. It involves identifying needs, sourcing suppliers, negotiating terms, finalizing the purchase, and keeping proper records. The Office of Procurement Regulation, or OPR, is an independent body established under the Public Procurement and Disposal of Public Property Act 2015. The legislation encourages public bodies to incorporate sustainable procurement practices that will help them to manage our waste products using sustainable disposal practices, ensure ethical and responsible treatment of staff and communities, build and manage our sustainable production capacity through education, training, environmental management systems, monitoring and reporting. So what changes can you make? Well, start with just one. Sustainable procurement is our collective decision to choose energy-efficient equipment and appliances, eco-friendly products with less packaging, ethically produced and certified fair trade products, equal tender opportunities for local and small suppliers. One change in your procurement, one new responsible action today can make a huge impact for sustainable results. Yes, it may require a little more research and planning, but incorporating sustainable procurement practices will protect our public purse as we make more effective and efficient use of human, natural and financial resources. And as the demand increases, producers will produce more products that are environmentally friendly, resource efficient and safe for all. To find out more about how you could devise and implement innovative practices in sustainable procurement, visit the resources section of our website, oprtt.org. Saving our world. It's a topic that we've heard much talk about in recent years as climate change continues to cause many countries to take stock of their contribution to this global crisis. Here in Trinidad and Tobago, the Office of Procurement Regulation is committed to doing all that we can to ensure that our public bodies keep their demands on global natural resources to a minimum. But in an age so heavily driven by consumerism, the drive to reducing our eco-footprint needs to be championed at all levels, including procurement. Procurement is a business's process of acquiring goods and services. It involves identifying needs, sourcing suppliers, negotiating terms, finalizing the purchase, and keeping proper records. The Office of Procurement Regulation, or OPR, is an independent body established under the Public Procurement and Disposal of Public Property Act 2015. The legislation encourages public bodies to incorporate sustainable procurement practices that will help them to manage our waste products using sustainable disposal practices, ensure ethical and responsible treatment of staff and communities, build and manage our sustainable production capacity through education, training, environmental management systems, monitoring and reporting. So what changes can you make? Well, start with just one. Sustainable procurement is our collective decision to choose energy-efficient equipment and appliances, eco-friendly products with less packaging, ethically produced and certified fair trade products, equal tender opportunities for local and small suppliers. One change in your procurement, one new responsible action today can make a huge impact for sustainable results. Yes, it may require a little more research and planning, but incorporating sustainable procurement practices will protect our public purse as we make more effective and efficient use of human, natural and financial resources. And as the demand increases, producers will produce more products that are environmentally friendly, resource efficient and safe for all. To find out more about how you could devise and implement innovative practices in sustainable procurement, visit the resources section of our website, oprtt.org. Saving our world. It's a topic that we've heard much talk about in recent years as climate change continues to cause many countries to take stock of their contribution to this global crisis. Here in Trinidad and Tobago, the Office of Procurement Regulation is committed to doing all that we can to ensure that our public bodies keep their demands on global natural resources to a minimum. But in an age so heavily driven by consumerism, the drive to reducing our eco-footprint needs to be championed at all levels, including procurement. Procurement is a business's process of acquiring goods and services. It involves identifying needs, sourcing suppliers, negotiating terms, finalizing the purchase, and keeping proper records. The Office of Procurement Regulation, or OPR, is an independent body established under the Public Procurement and Disposal of Public Property Act 2015. The legislation encourages public bodies to incorporate sustainable procurement practices that will help them to manage our waste products using sustainable disposal practices, ensure ethical and responsible treatment of staff and communities, build and manage our sustainable production capacity through education, training, environmental management systems, monitoring and reporting. So what changes can you make? Well, start with just one. Sustainable procurement is our collective decision to choose energy-efficient equipment and appliances, eco-friendly products with less packaging, ethically produced and certified fair trade products, equal tender opportunities for local and small suppliers. One change in your procurement, one new responsible action today can make a huge impact for sustainable results. Yes, it may require a little more research and planning, but incorporating sustainable procurement practices will protect our public purse as we make more effective and efficient use of human, natural and financial resources. And as the demand increases, producers will produce more products that are environmentally friendly, resource efficient and safe for all. To find out more about how you could devise and implement innovative practices in sustainable procurement, visit the resources section of our website, oprtt.org. Saving our world. It's a topic that we've heard much talk about in recent years as climate change continues to cause many countries to take stock of their contribution to this global crisis. Here in Trinidad and Tobago, the Office of Procurement Regulation is committed to doing all that we can to ensure that our public bodies keep their demands on global natural resources to a minimum. But in an age so heavily driven by consumerism, the drive to reducing our eco-footprint needs to be championed at all levels, including procurement. Procurement is a business's process of acquiring goods and services. It involves identifying needs, sourcing suppliers, negotiating terms, finalizing the purchase, and keeping proper records. The Office of Procurement Regulation, or OPR, is an independent body established under the Public Procurement and Disposal of Public Property Act 2015. The legislation encourages public bodies to incorporate sustainable procurement practices that will help them to manage our waste products using sustainable disposal practices, ensure ethical and responsible treatment of staff and communities, build and manage our sustainable production capacity through education, training, environmental management systems, monitoring and reporting. So what changes can you make? Well, start with just one. Sustainable procurement is our collective decision to choose energy-efficient equipment and appliances, eco-friendly products with less packaging, ethically produced and certified fair trade products, equal tender opportunities for local and small suppliers. One change in your procurement, one new responsible action today can make a huge impact for sustainable results. Yes, it may require a little more research and planning, but incorporating sustainable procurement practices will protect our public purse as we make more effective and efficient use of human, natural and financial resources. And as the demand increases, producers will produce more products that are environmentally friendly, resource efficient and safe for all. To find out more about how you could devise and implement innovative practices in sustainable procurement, visit the resources section of our website, oprtt.org. Saving our world. It's a topic that we've heard much talk about in recent years as climate change continues to cause many countries to take stock of their contribution to this global crisis. Here in Trinidad and Tobago, the Office of Procurement Regulation is committed to doing all that we can to ensure that our public bodies keep their demands on global natural resources to a minimum. But in an age so heavily driven by consumerism, the drive to reducing our eco-footprint needs to be championed at all levels, including procurement. Procurement is a business's process of acquiring goods and services. It involves identifying needs, sourcing suppliers, negotiating terms, finalizing the purchase, and keeping proper records. The Office of Procurement Regulation, or OPR, is an independent body established under the Public Procurement and Disposal of Public Property Act 2015. The legislation encourages public bodies to incorporate sustainable procurement practices that will help them to manage our waste products using sustainable disposal practices, ensure ethical and responsible treatment of staff and communities, build and manage our sustainable production capacity through education, training, environmental management systems, monitoring and reporting. So what changes can you make? Well, start with just one. Sustainable procurement is our collective decision to choose energy-efficient equipment and appliances, eco-friendly products with less packaging, ethically produced and certified fair trade products, equal tender opportunities for local and small suppliers. One change in your procurement, one new responsible action today can make a huge impact for sustainable results. Yes, it may require a little more research and planning, but incorporating sustainable procurement practices will protect our public purse as we make more effective and efficient use of human, natural and financial resources. And as the demand increases, producers will produce more products that are environmentally friendly, resource efficient and safe for all. To find out more about how you could devise and implement innovative practices in sustainable procurement, visit the resources section of our website, oprtt.org. Saving our world. It's a topic that we've heard much talk about in recent years as climate change continues to cause many countries to take stock of their contribution to this global crisis. Here in Trinidad and Tobago, the Office of Procurement Regulation is committed to doing all that we can to ensure that our public bodies keep their demands on global natural resources to a minimum. But in an age so heavily driven by consumerism, the drive to reducing our eco-footprint needs to be championed at all levels, including procurement. Procurement is a business's process of acquiring goods and services. It involves identifying needs, sourcing suppliers, negotiating terms, finalizing.
Good afternoon and welcome back to the question and answer segment of the Office's Roundtable discussions. So we do have some questions coming in from the audience. So the first question we have is for you, Mr. Gray. In your experience, what is your approach to managing risk and contingency planning within procurement activities?
Well, I'll take it from a practical, as the person said, from my experience, because I know we have some stud accountants here that can answer that. You have to decide in the procurement activity 3 things. Preventative, whether you're going down the road of preventative risk, detection, and or investigative. One of our CARICOM neighbors had a similar organization, they call it the Contractor General, and they focused on preventative. So for example, if there was a state project in building a highway or something like that, they will actually start their audit process in line with the start of that procurement activity. So in other words, they are there as it's going on to prevent any sort of issues in the long run. The reason being, sometimes we say investigations from a state level, but running down investigations could take time, effort, statute of limitations could exist. So I would say a big part of it is to decide how you mix between preventative, detection, and investigative risk. Put it in those 3 buckets, because we are accustomed with the materiality level. We are accustomed with the other issues. Right? The detection risk will be things that will give you that red flag that something is going on. I've seen, for example, state enterprises, let's say, unsigned contracts. Unsigned, you know, it could be a whole host of things that could give you that red flag. So I would say those 3 issues, and one last thing would be whether or not, because we have had audits throughout the years, we have had compliance audits, and then when you watch the management letter, you watch the recommendations, none of it has been implemented. Yeah? And that creates a big gap. So let's say your audit department goes into a state enterprise. I won't be surprised to hear that when they think that this is an offense or this is not in compliance, when they try to reconcile it back to black and white, whether that organization has it in their policy and procedures. It might well be that the policies and procedures were last updated in 1991. So, and that will now, you know, take some shine of the legality of their findings. Because the first thing, the defense, I'm going to say, what policy and procedure did I breach? A simple thing as a travel and entertainment policy. Good? What did I breach if you don't have none of that? Or what did I breach if you don't have key clauses in that? I'm not liable for that. Right? And that is one reason why a lot of cases go to the industrial court from organizations and they are lost. Yeah? So the continuous auditing and also checking to see whether your management letter points or your compliance points have been updated into the policy and procedures of the organization.
Okay, great. Thank you very much, Mr. Gray. We have a question from Mrs. Nanan. What considerations would be given to internal audit activities within the public bodies so as to prevent duplication of efforts?
So, Marisa, I'll answer that twofold in that it will depend on the public body and what I would refer to as their internal audit department or their compliance department. What we would look at is to see if it is this a checklist that the public body is engaging in that, let's just say the Public Accounts Committee has mandated that an internal audit department be set up in the public body. When we look at the audits that are being conducted, how frequently they are being conducted, as Mr. Bowler would have indicated earlier, in terms of the auditing standards. Are there any standards that are being complied with the IASs, the international best practices, that the accounting fraternity, is there any compliance there? And when we look at that, and if we can determine, well, there is a standard within the organization that we feel comfortable with in terms of looking at their work, looking at, as Mr. Gray would have just indicated, in terms of their management letters, their management action report. Is it based on what the internal controls that would have been tested by the internal audit department, based on the outcomes that would have been reported to the audit committee at the public body, how is management treating with it? Is it that the action plans are being actioned, or is it the management action plans are just sitting on a shelf and there's no implementation of that plan? So when we look at that, yes, we can take that report and now say, okay, there are 3 areas of procurement that has been highlighted in the internal audit report, and we can look at that. That is not to say that the internal or the audit and investigation department will rely on that report or will take that report wholesale and say, well, these are the 3 areas that we think that they are in breach of in terms of the act, and those are the only 3 areas that we will be looking at. The audit and investigation department of the OPR will be coming to the public bodies and will be coming to the public bodies independently to look at those breaches or those compliance with the act.
Okay. So on the heels of that question, Shad, I have another question for you. Would the annual audit plans be shared with public bodies for proper planning and scheduling of compliance type audits?
As much as I would love to share that plan with the public bodies, I will say no to that. However, public bodies will be given notice in terms of when the audit and investigation department will be coming in some instances, and I'll clarify. Upon an audit, at the start of an audit, when the audit and investigation department comes to audit, let's just say any public body, what we will be required, just as in an internal audit or an external audit, is that we give notice to the management. Notice that the OPR is coming, these are the staff you should expect, this is the time frame in which we will be staying at your organization. But more importantly, the list of requirements that we will be, the public body will be required to provide to the audit and investigation department. So they will get that notice ahead of time. However, in some instances, an audit may take place in the instance where we will not be able to give notice to a public body. So I would say in the majority of cases, based on the audit plan, we will be given public bodies notice, and I would say sufficient notice as well. But there are some instances that we may not be able to give a public body notice that an audit may be going to be, may take place.
Okay, great. Question again, what is the time frame for state enterprises to implement a handbook or procurement policy? Also, in developing such, can the procurement policy in some cases contradict to the SCPMM?
I want to start with the latter part of the question, yes. And to the SEMP manual, I would say no. The Act will not be in contradiction, or our handbooks and guidelines will not be in contradiction to the SEMP manual. With regard to the handbooks and guidelines, I want to say that the OPR, we have on our website, we have 32 plus handbooks and guidelines that are currently available to the public bodies so that they can start implementing now. So it's not that they have to wait until proclamation for them to say, well, I need to go and get a handbook and guideline, yes, for our organization, and then I need to prepare that handbook and guideline. The handbooks and guideline has to come to the office, so that would depend on when the public body sends it to the office as well. And in some instances, some public bodies will be required to have special handbooks and guidelines. So again, that would depend on the public body when they prepare those handbooks and guidelines, which special handbooks and guidelines that they will be adopting. But as of now, the OPR has available handbooks and guidelines on our website that the public bodies, they can go in, they can take a look at it. They can feel free to, yes, adopt it wholesale, as they say. Yeah. So yeah, it depends on the public body.
Okay, another question. And if public bodies do not have any of these policies in place, can they still be investigated?
Yes, yes. The public, but once the act is proclaimed, it becomes, as Ms. Ashby would have said, it becomes legislation, and it will be required to, we will be required to adhere to the legislation or the laws of the land. And that legislation requires the office to investigate public bodies. And I think that will be a red flag, as I would have indicated earlier, in terms of one of the criteria by which we will determine in terms of risk is, yes, does the public body have handbooks and guidelines? And if they don't, then what are you following in terms of your public procurement? How are you engaging in that public spend, yes, for procurement activity? So I will say definitely yes. It will probably be one of those entities that will be engaging in an investigation first.
Okay, great. Thank you very much, Mrs. Nanan. Please stay logged in. We do have more questions to come, but we need to take a short break, and we will be right back.
Saving our world. It's a topic that we've heard much talk about in recent years as climate change continues to cause many countries to take stock of their contribution to this global crisis. Here in Trinidad and Tobago, the Office of Procurement Regulation is committed to doing all that we can to ensure that our public bodies keep their demands on global natural resources to a minimum. But in an age so heavily driven by consumerism, the drive to reducing our eco-footprint needs to be championed at all levels, including procurement. Procurement is a business's process of acquiring goods and services. It involves identifying needs, sourcing suppliers, negotiating terms, finalizing the purchase, and keeping proper records. The Office of Procurement Regulation, or OPR, is an independent body established under the Public Procurement and Disposal of Public Property Act 2015. The legislation encourages public bodies to incorporate sustainable procurement practices that will help them to manage our waste products using sustainable disposal practices, ensure ethical and responsible treatment of staff and communities, build and manage our sustainable production capacity through education, training, environmental management systems, monitoring and reporting. So what changes can you make? Well, start with just one. Sustainable procurement is our collective decision to choose energy-efficient equipment and appliances, eco-friendly products with less packaging, ethically produced and certified fair trade products, equal tender opportunities for local and small suppliers. One change in your procurement, one new responsible action today can make a huge impact for sustainable results. Yes, it may require a little more research and planning, but incorporating sustainable procurement practices will protect our public purse as we make more effective and efficient use of human, natural and financial resources. And as the demand increases, producers will produce more products that are environmentally friendly, resource efficient and safe for all. To find out more about how you could devise and implement innovative practices in sustainable procurement, visit the resources section of our website, oprtt.org. Saving our world. It's a topic that we've heard much talk about in recent years as climate change continues to cause many countries to take stock of their contribution to this global crisis. Here in Trinidad and Tobago, the Office of Procurement Regulation is committed to doing all that we can to ensure that our public bodies keep their demands on global natural resources to a minimum. But in an age so heavily driven by consumerism, the drive to reducing our eco-footprint needs to be championed at all levels, including procurement. Procurement is a business's process of acquiring goods and services. It involves identifying needs, sourcing suppliers, negotiating terms, finalizing the purchase, and keeping proper records. The Office of Procurement Regulation, or OPR, is an independent body established under the Public Procurement and Disposal of Public Property Act 2015. The legislation encourages public bodies to incorporate sustainable procurement practices that will help them to manage our waste products using sustainable disposal practices, ensure ethical and responsible treatment of staff and communities, build and manage our sustainable production capacity through education, training, environmental management systems, monitoring and reporting. So what changes can you make? Well, start with just one. Sustainable procurement is our collective decision to choose energy-efficient equipment and appliances, eco-friendly products with less packaging, ethically produced and certified fair trade products, equal
Common regulations, roundtable discussions, Q&A segment. So we do have another question for you, Mrs. Nanan. Would the public bodies be given the opportunity to perform internal investigations prior to initiation of external reviews?
So I would make the assumption that that is with regard to a breach of the Act and that it relates to public procurement. And I would say yes to that question in that any public body can initiate an investigation internally. I would suggest and I would recommend that they do in terms of if they feel that there is a breach or there's a non-compliance and there is an internal audit department and an audit committee, that sort of engagement takes place so that the public body, they don't need to wait until the Office of Procurement comes to investigate or you are served with an ex parte order that you realize, well, there is an investigation or there is something that is going wrong at your organization. So public bodies encourage, if it is that they feel that there are breaches in the Act or breaches in terms of what the Act stipulates and how public procurement should take place at the public body, they should definitely engage in an investigation prior to the audit coming in.
Okay, great. Well, thank you for that tip, Mrs. Nanan. There is another question. Are there OPR procedures, audit procedures in place that can be shared with the public bodies so that the expectations of the audit process are clear?
I would say yes, and I would say that has been done already in that the OPR, by our capacity department, they have developed what we would call our compliance checklist. And that compliance checklist speaks to what the Act requires from a public body as it relates to, upon proclamation, what you will be required to comply with as the Act outlines. So I would suggest to the public body in terms of if you want to mirror what the audit and investigation function will be looking at when they come to your organization, is to take a look at the compliance checklist. You can see where you are at in terms of compliance with that checklist. And again, if it is that you feel that you want clarification, the organization, the OPR, has been doing numerous stakeholders engagement. We have persons who would send us questions on a weekly basis, so they can feel free to send us those questions to get the clarification, or they can request that we come in and we do a training session with them or a stakeholder engagement session, and we will clarify any questions that they might have where they feel that they are not in compliance with that checklist.
Okay, great. Another question for you, Mrs. Nanan. Does the OPR have a time frame to notify public bodies of an investigation?
The OPR, I will say no to that. Again, an investigation, as Mr. Gray would have indicated, in most instances, an investigation, you don't know that an investigation is taking place until the investigation has reached its latter stages, and then you need to notify if persons has to be interviewed or at some point in time notified because there's a requirement to do that. They will do that. As I would have indicated earlier, because the ex parte order is needed in the instance where it is that we are unable to get the documents, record, personnel, and file, that the public body will be notified. But to say that we will give notice that an investigation is coming, I will say no to that.
Okay, great. We have a question from Mr. Gray. How can a bumped up budget be detected?
Well, I mean, budget is you have to take it by line item. It's very simple.
Yes.
You have a price and you have quantity, right, or unit. The first things we do is you test your market prices. Good? So that's one indication. And the second thing, you test your quantities, whether you need a need specification, whether you need those quantities, or does it mirror in your past ordering of those quantities, and you dive into either the price or the quantities by line item.
Okay.
Yeah.
Okay, great. Thank you very much, Mr. Gray. So we have a question coming in for Deputy Chairman Robbie Bowler. Any guidance as to how an exemption item listing be determined? Is it based on any set requirements, or a public body can feel free to not go through the procurement process by adding items onto the exemption listing?
Thank you, Marissa. Now, the exempted services are defined in the Act within Section 7(6) of the Act. Public bodies cannot exempt services themselves. Any exemption that must come must be initiated by an order via the minister.
Okay, great. Thank you very much, Deputy Chairman. To Mrs. Nanan, how ready are state agencies to implement the Public Procurement and Disposal of Public Property Act?
Very good question. I would say we wish they were a lot more ready than they currently are. But we have issued a readiness assessment for all public bodies, and I would say that public bodies are at different stages. So to say we have 10% that are fully compliant with the Act, we have them at varying stages in terms of readiness.
Yes. Okay, great. Thank you very much. Another question to Ms. Nanan. Would the OPR be utilizing consultative services, external to the OPR, to perform investigations of public bodies? If so, are audit standards and information confidentially maintained?
I would say yes to that. Just like we advise public bodies that they have to be pre-qualified, the OPR will be engaging in the same activity in terms of pre-qualifying those contractors or experts that we will be utilizing, or that we have actually already established a list of experts specifically for the field of the audit and investigation department that we will that we feel that we will utilize in the future when the Act is proclaimed. So based on that listing, what we will try to do is try to pre-qualify persons to put them in our database, and from there we will utilize those services. For all persons who are going onto the database, all suppliers and contractors that will be used by the public bodies, not just those for the audit and investigation department or for the experts that we will be utilizing, all persons, they will be required to have that level of confidentiality when they engage a public body in terms of the goods and services that will be procured.
Okay, thank you very much. So those are all the questions today. Before we wrap up, any other comments or further contributions by the members of the panel?
I would just like to suggest, I would like to see the OPR in full operation soon, and that I think will help in the public procurement area. So, the sooner this Act can be implemented and the OPR becomes operational, I think it's going to be beneficial for both public and private.
Okay, great.
I just want to add to what Mr. Irish is saying, in that the Act and this new legislation, it's something that will move our country forward, in that we can benefit. Every person in Trinidad and Tobago can benefit from the proclamation of this Act. So we at the OPR, we look forward to the proclamation of the Act and to the compliance by public bodies.
Okay, great. Well, thank you to all of the panelists today, and thank you to the viewing audience for your questions as well as your participation. If you want to keep abreast of any further commitments that the office have coming up, or any further discussions or sensitization sessions, please make sure that you monitor our website. So thank you again, and please have a safe afternoon.
Saving our world. It's a topic that we've heard much talk about in recent years, as climate change continues to cause many countries to take stock of their contribution to this global crisis. Here in Trinidad and Tobago, the Office of Procurement Regulation is committed to doing all that we can to ensure that our public bodies keep their demands on global natural resources to a minimum. But in an age so heavily driven by consumerism, the drive to reducing our eco-footprint needs to be championed at all levels, including procurement. Procurement is a business's process of acquiring goods and services. It involves identifying needs, sourcing suppliers, negotiating terms, finalizing the purchase, and keeping proper records. The Office of Procurement Regulation, or OPR, is an independent body established under the Public Procurement and Disposal of Public Property Act 2015. The legislation encourages public bodies to incorporate sustainable procurement practices that will help them to manage our waste products using sustainable disposal practices, ensure ethical and responsible treatment of staff and communities, build and manage our sustainable production capacity through education, training, environmental management systems, monitoring and reporting. So what changes can you make? Well, start with just one. Sustainable procurement is our collective decision to choose energy-efficient equipment and appliances, eco-friendly products with less packaging, ethically produced and certified fair trade products, equal tender opportunities for local and small suppliers. One change in your procurement, one new responsible action today can make a huge impact for sustainable results. Yes, it may require a little more research and planning, but incorporating sustainable procurement practices will protect our public purse as we make more effective and efficient use of human, natural and financial resources. And as the demand increases, producers will produce more products that are environmentally friendly, resource efficient and safe for all. To find out more about how you could devise and implement innovative practices in sustainable procurement, visit the resources section of our website.